Hang on, I should go the other way. Just a second.
All right, let's see if we can go ahead and get started this morning. What's that? It's he's got a machine. It's going to show up back there. It may not be a speaker that's going to be out loud. So welcome to Houston. James Jorison is our speaker this morning, and Secrets of the Credit Industry.
Thank you.
Secrets of what?
Secrets of the Credit Industry 2, actually. All right, just a second here. I got to find one thing, which isn't here. That's not good. 1, 2, 3. Oh, there it is. Covered it up. We're going to do a plug for a friend. Richard Cornforth is one of the reasons why I'm here, because I stood in for him in Las Vegas, and that started my whole escalades here. Kind of reluctantly in the beginning, but now it's kind of fun. The first topic we're going to do is ultra vires. Ultra vires is when a corporation acts outside the authority of the corporate charter or outside the authority of law. If a VIRES. And it's kind of funny. The first case I found was in 1875. And it was where a national bank was trying to loan credit. And it was found to be illegal and outside the charter, because all the banking charters and everything that they had, they couldn't hypothecate credit. Everybody thinks they do now, but basically that law is still on the books, and that case law is still on the books.
What's the name of the case law?
Well, there's a bunch of them. You have F and PR versus Richmond, which is 133 Southeast Reporter, page 888. That's kind of cool. And then you have Community Federal Savings and Loan versus Fields, which is 128 Federal Supplement, 2nd edition, 705. And there's a bunch more. It's in the book you're going to get about at noon. But what it is if it isn't in the banking charter allowing them to do it, they can't do it. Okay? If it's outside law, they can't put it in the charter to do it to be legal. Okay, those are the two things that they can't do. Now, usually when a court acts outside its authority, if a court under the law of voids doesn't have subject matter jurisdiction, the court's acted under ultra vires by proceeding without jurisdiction. So it's neat because a lot of things. It makes it illegal for the banks to do certain things, which is a good thing. And it goes through all the summaries of all that. The law of voids is about 5 pages of information. And then there's a CD that'll have all the about close to 10,000 exhibits that's going to be for sale, but it has all the case laws on the CDs. But the interesting thing is, what I started in banking and understanding banking was from the credit bureaus. Then I went from the credit bureaus to the debt collectors, and then from the debt collectors to the banks, and then from the banks to the courts for foreclosure to find out how the banks enforced everything. And the banks are usually they're only looking at it one way, and that's under if they violate the Fair Credit Reporting Act or if they have the right to collect it. Those are the only 2 laws that they look at. They forget a lot of them. One of the main laws that they forget is the Fair Credit Billing Act. And I like the Fair Credit Billing Act because you can ask for validation under the Fair Credit Billing Act, Fair Debt Collection Practices Act, and Fair Credit Reporting Act. And you ask them to validate the debt under all 3.
All 3?
All 3 of them at the same time. What happens is they have to provide the original, on the Fair Credit Billing Act, they have to provide the original copy of the original application that you signed. And because the actual contract did not come with the application, they have to provide you with the original terms of the agreement of the application that you signed. Okay, so if you signed it way back in '86, and you're asking for it now, they have to present you with the contract that you signed originally in '86.
They don't have it.
Well, there's another act that they forget about. The other act that they forget about is the Equal Opportunity Act. The Equal Opportunity Act states that they have to keep all information on everybody that applies for a loan for 25 months. So Bank of America keeps it for 48 months, and then they destroy the applications and all the original documentation, which means they don't have it. All they have is an electronic file, and they don't have the hard copy that they're supposed to use to back up the debt.
So they can't try to prevent that in.
No, they have nothing to take to court.
I mean, they can't just print one out and that judge says that's good enough.
No, that's not evidence. A copy is not evidence, yes.
How many months did you say they have to keep it?
By law, they have to keep it 25 months. Bank of America keeps it the longest, it's just 48 months.
Aren't there some courts, though, that are allowing the electronic evidence to be admitted?
It depends on who is representing the evidence to the court. That comes into under ultra vires, who can testify for a corporation. There's only 4 people that can testify for a corporation: the vice president, president, CFO, and secretary. But the secretary that they always say is the one that writes the thing is not the secretary of the corporation. Or the person that reviews the file. If they review the file, it's not their file. So there's a lot of things that they don't do that they're supposed to do, that they don't do. And the main thing that they do is that because they don't do the validation, because the records are destroyed, they have nothing to bring to court. And they don't do it through an officer of the corporation, which means nobody can testify for the corporation. Who do they usually bring? You got an attorney on this side, and you got an attorney on this side. Nobody shows up. So if the attorney's sitting there talking, there's nothing going on the record. He could talk all day.
All day long.
And it'd be a void under the law of voids. So it's a combination between all these things that they don't do. And 90% of the time, even if they have a judgment signed, sealed, and delivered by the court, and if you, under the Fair Debt Collection Practice Act, state that I'd like you to validate this debt, and they have a judgment, okay, all they have to prove, they just have to show you the judgment. But they never do that. They just send it to Lucy or Sally over here, and they type it out on the computer, print it out, and guess what happens? You owe the debt, because I say you do right here. No proof. You owe it. Okay, if for instance, under the Fair Debt Collection Practices Act, you were to ask them to validate the debt, and they didn't, and they still just provided you a letter, it's not validation either way.
What is your definition of validation?
A validation goes under corporate law for a corporation. If it's a corporation, it has to go under the corporate bylaws of the corporation, which means there has to be minutes. The corporation has to tell you what it is that you owe the corporation. So the board has to convene. They have to put it down. They have to vote and say, this is, yes, he does owe us this amount of money. Then they have to issue the resolution. Then the resolution of the corporation has to have the seal placed on it. Then the resolution is issued with the seal. Then they send that to the court with a representative from the board saying, yes, you owe it.
And that is where that definition.
That definition, that's how corporate proceedings work. That's the law. When they put the seal on the corporate resolution, that's executing the resolution for the corporation, saying what the corporation says it's supposed to do, or what the person owes.
That's when you're making the loan, or
No, that's when they ask to validate it.
To validate.
That's the procedure that they should do if they're a corporation.
is that the procedure they use when because the credit union that we've gotten loans from, they say they're meeting on a certain time and they're going to vote on it. We don't know why they vote.
Because they're announcing publicly that they're a publicly traded company, and they're announcing that they're having a meeting so that people can show up to vote on it, to be a part of the proceedings. See, there's a difference between corporate law and sole proprietorship law. And then you got different types of structures of different companies, but they all fall under certain things. Now, for instance, a trust. A trust has to have bylaws. A trust also has to have minutes. If a trust does not have minutes or bylaws, it's not a trust.
Right.
It's a fiction. Because there's no intent. It doesn't tell what the intent of the trust is or what they're doing. So the combinations of how those entities work together and how those entities sue a person, they have to abide by their rules to do it. And they take the simplest way. They send you a letter. And one of the funniest letters, and I've seen like 4 different versions of it, but it basically states, under the theory of quantum merit, you owe us $5,000. Please pay, or we'll have to sue. I never heard of these guys in my life. Now, I was getting all sorts of letters. I got in a bad car accident, and I had letters up the yin-yang, man. They were sending tons of letters, and I couldn't read, couldn't do anything. I just got this stack of letters coming, and I go, yeah, it'd be cool to know what that says. Let's put it over here for right now. I didn't have a clue what it said, so I had this huge stack. And then I got to looking through them all, and I'm going like, I don't know any of these people. Whether I owed them or not, I didn't know because I didn't have any memory of the debt. So that caused all sorts of fun stuff with them and trying to get them to provide information and stuff. Yes, sir.
What happens when a judge is ruling on their favor disregarding any request that you would have for validation of that debt?
Okay, then what you're asking me is if they sue you and you sue them, or they just sue you and you go to court and they go to court and they win in the lower court. It's not over yet.
You still appeal.
No, you got appeals, you got all sorts of things. You got to go take it to the next court level because you don't know if that court acted. Now let's say, for instance, it's a court action like one that happened the other day. There's a gentleman that went into court and was asking that he would be assistance of counsel. And he had called me and asked me what he should do, and it's funny. Basically what happens is they went to court, they asked the court said, well, we've made a ruling on this. And I go, we're not asking your position on this. We're stating that this is who we are. This is who this person is. He's my choice of assistance of counsel. And then the judge is going to throw him out of court or overrule them. And they said, well, says, Your Honor, we're going to have to do an interlocutory appeal immediately. You'll have to stay the court proceedings until that appeal is done because we have to find out whether you have jurisdiction to do it or not. To deny the process. And then the judge said something like, we're striking that all from the record as they were leaving. But there was a tape recorder going on, and it's funny. But anyways, the really funny part is that the one thing that I've wanted somebody to do is to do that. Because then what happens is then you take and appeal it to the next court court's going to rule the same as this guy down here. Go to the next court, it gets to the appeals court. If it's the Ninth Circuit Court of Appeals, forget it. They're going to rule wrong no matter what they do. It doesn't matter. That twice they've ruled right because they knew that they were going to be overturned if they didn't rule right. So then you go all the way to the Supreme Court, and the Supreme Court's going to overturn everybody down the road and tell them this is what they're supposed to do. A prime case in this state, though, one judge sued another party, got a judgment against that party, went into Colorado, stole a $600 trillion gold mine, okay, has taken, sold off properties, sold water rights, sold everything off of this property. It's gone to the Supreme Court of Texas twice. It's been ordered to be overturned and reversed and go down and have a proceeding. Okay? They've refused to do it. It's been 20 years from when the case started. It's gone to the Supreme Court of Texas twice. Now, you look on one side, if you look and read the documents that the attorney prepared for the party, he screwed up in the documents. All he had to do is change one phrase. Very last part. First part was, please send it back to the same judge that did it down here, and please let him overrule himself. Well, these guys are buddies down here, so they're friends, so they didn't, and he's not going to overrule his buddy because they're buddies, right? What he should have done was he should have put the phrase in, I want the Supreme Court of Texas to rule right now on whether this is void or not. So then the Supreme Court rules that it's void, It's void. It's out. It's dead. It's done right there. But no, each time this attorney did something, he said, please bring it back to the lower court and have a trial on it. Why do you want them to go down there? They've already had like 5 shots at it. So you take it up to the Supreme Court and have the Supreme Court rule on it. You want them to rule. You don't want them to send it back to further proceedings. And you'll see that a lot in the arguments of if you read case law, it says further proceedings to forthwith. It meant that the person didn't really want the Supreme Court to rule for him. He just wanted to go back to the court and have trial to make what? More money. Instead of ending it and having finality when it went up the second time. That one's really going to cause a lot of problems because there's a gold mine, and the land that they sold, 2 cities are going to owe close to, they're basically just going to hand them the deeds to the cities. I mean, the one city's already said, we're going to just hand you the deed. Because they owe $70 million a year in water rights for 20 years. Okay, and then not only the property they stole, one of the hotels cut into the mountain, took the gold out of the mountain, had it processed, paid for the hotel to be built, but it wasn't their gold, it was the gold for the mine. So it's kind of funny. But if you stop at the first proceedings, you don't know who's right because you don't know whether that judge did what he was supposed to do that was right.
Oh, boy.
I mean, because it's not over. Now, 99% of all the people stop right there. Oh, I lost.
Yeah.
Was I right? Oh, I don't know yet. Nobody's opened up the record, gone the file, opened it up, looked in the file, looked page by page. Yep, they had a witness there. He testified. Yeah, he did that and added proof. Okay, I guess it stands. They don't do that. That's what a review is. A review is supposed to look at the record, see if they brought their witnesses. If there's no witnesses, there's no case. If there's no case, it's a void. It's kind of fun. So you go back to the debt collectors. They're really fun. A lady, you can give, I learned this from the Assistant Attorney General of the state of Colorado. Her name was Marlene Mansfield. I think that's her last name. I'm probably butchering it pretty good. But what she did, I asked her a question. I go, what happens if you give them a debt collector a letter saying, don't contact me under any circumstances under the Fair Debt Collection Practice Act? And they get a judgment against you. You didn't show up, so they got the judgment. And they call you on the phone to collect, how are you going to pay this judgment? All right, when they called on the phone asking you how to pay the judgment, they violated the Fair Debt Collection Practice Act. Now what they were trying to collect from you, they can't. Now they owe it to you.
Can you really do that, Bill of Judgment?
That was a violation of the act. You said, do not contact me under any circumstances about anything.
Even by mail?
No, they can't do it by mail. They can send, if you send them a correspondence, they can send you one letter back stating that they are going to proceed with all further actions that they could possibly think of they're going to try to do.
So is it legal to say, don't contact me at all?
Yeah, it says it in the Fair Debt Collection Practice Act. I do not want to deal with you, and I can take and only deal with the original creditor.
Okay.
I don't have to choose to deal with them. That doesn't mean that they can't go get a judgment. You don't show up, they get their judgment. They go to enforce their judgment. They go to garnishment. All of a sudden you're getting your check and money's coming out of your check. Well, they didn't have to tell you. They just followed all the legal procedures that they could do. But if they call you on the phone to ask you about it, how you're going to pay it, well, then they violated the act. And she said that and I almost fell out of the chair. Oh, you're kidding. Just a second, I got to call some people. You know, it was,
Except they never have to contact her, do they? If they've taken her money out of her check.
if they get a judgment and they go directly to garnishment, they can take whatever they want out of your check. What they do is put a demand draft there. Demand draft. Sitting there waiting. Money hits the account, demand draft comes in, rips out the money, take off, they're gone. They got their money, they're happy. You bounce 40 checks. But there's a demand draft there, which meant anytime the money hit the account that they were able to take it right out. So that's what they could legally do, but they never follow those procedures. They just want you to make it easy. They call you up. We don't want to really do nothing. We just want your money. Give us the money. You owe us the money. We got a judgment. What are you going to do about it? Well, ask me this. Is that judgment void? No,
But
I got
how
a
do you-
default judgment. Oh, is it
how do you
void?
Prove it though that they called you.
How do you prove that they called you? Star 69 is what it was invented for.
Oh, that's right. Yeah, and then you get the police to give you the,
No, what you do
report.
is you just have, all they have to do, they'll admit that they called you. Yeah, we called.
Can you send me something in writing on that?
Oh, in this state, it's really good. This state's kind of like Colorado. It's really good. What my friend of mine did is we got 24 letters to show up at his house from the same debt collector. He settled out of court with the debt collector. They paid him $1,000. He waited till the check cleared. Then he took the 24 letters, took them down to the Attorney General's office, said, this debt collector isn't licensed to collect in the state. They didn't pay the $300 fine, so therefore they owe you a $10,000 fine for every letter they sent in the state. Here's 24. That's $240,000 they owe you. Guess what happened to the debt collector? He had to declare bankruptcy. 3 of them. Texas has the same law.
You know what the name of that law is, or the statute or whatever?
It's under the collection laws of the state. You look under debt collectors in the state code, and it'll show you the laws that are governed by the debt collectors, what they have to do and cannot do, and the license requirements of that. And it's usually probably somewhere around a $300 fee to get the license. But it's usually, in Colorado, it's a $10,000 fine if they don't buy the $300 license
Per infraction.
per letter. See, but then the Attorney General goes and looks to see how many people they sent letters to in the state through discovery from them when they sue them to find out. Yeah.
Does that include law firms?
No. Unless the law firm has 2 people named Sally and Lucy calling up on the phone asking you for debt, and that's their whole job is for them to call on the phone to collect debt. In Colorado, they have to be licensed. The firm doesn't have to be licensed because they supposedly have a license. But if you look under the professional conduct code or professional business codes of each state, there's certain things within the states that each one has or hasn't had. That's where the code should be for the licensing requirement. So if attorneys did get licenses, they'd have to be in the professional code because it's a profession, like doctors and the other ones, right? Well, here's a question. How are the doctors licensed to do medicine?
Through a board,
Through a medical board, right? What's a medical board?
just a bunch of guys that are appointed.
It's a 501c3 nonprofit union.
Union,
Bar associations,
yeah.
501c3 nonprofits. They're a union. Okay, then you look under, like for instance in Colorado, look under the code. Anyone that creates a living trust in the code has violated the unauthorized practice of law statute.
Say that again.
States if you create a living trust in Colorado,
Oh, in Colorado.
you violate the unauthorized practice of law statute. The only problem is there is an unauthorized practice of law statute in all 50 states. The problem is there's no licensing requirement by any state legislature that they voted to elect through their proceedings to issue their joint act of state Congress to enact a law that licenses the attorneys in the first place. But they have one, they've enacted a law within the state legislature and passed it that says if they don't have one, they're in trouble.
All 50 states?
All 50 states. But they've never enacted a licensing way to get licensed because there's no statute. So if anybody would say, well, you are doing the unauthorized practice of law. Well, show me the statute that it pertains to and the act of legislation that passed it. Because I want to read the legislative act to see what the intent that the law is supposed to have in order for me to be licensed to find out whether I have to be licensed or not. I'll be happy to plead guilty. Just show me those 2 things.
Does that fit under family trust too?
Living trust?
Any trust
Any trust?
in Colorado. That's what Colorado's.
Colorado.
But he said that,
But it could fit other states.
Yeah.
The
There.
the principle has to do with the unauthorized practice of law, not trust specifically. It's any legal documents or preparations that one would do for another. So
Well,
When they come after you
the
for
specific-
unauthorized practice
Eh,
of law, that's what they're doing. So
In-
you're preparing documents they want attorneys to do that are in the union.
Well, yeah, but the whole statute in Colorado is specifically, it states, if you create a living trust, you violated the unauthorized practice of law. That's the only thing that the statute says. It doesn't say anything else. It just says if you create this, you've committed this act. And it doesn't say what the other acts are. So, I mean, it's kind of interesting. It's kind of like Las Vegas. Las Vegas, you can get a license for anything. Anything that's illegal is legal in Vegas because they licensed it to say that it's legal.
To get your
So what is a driver's license? It's a license to do something illegal to regulate driving. But because you pay for the license, therefore they gave you a license to commit an illegal act. Anything that is license required is an illegal act that they're racketeering.
Yeah.
So it's kind of, but the whole, getting off a little bit, but the whole thing on the credit is fun. Credit is a blast. I love credit because they always mess it up. They always.
What about these companies, credit card companies that force you to go to arbitration?
Okay, how can they force you to go to arbitration if there's no agreement to go to arbitration? And what is an arbitration agreement?
That's,
Somebody else is sitting there,
yeah,
and they agree with the other side, so they got an arbitration judgment, right?
yeah.
Right.
Then what do they have to do with the arbitration judgment to enforce it?
File it in your.
They file it in the county court, and guess what? Now you got a proceeding to find out whether what they have is real. Because if you didn't agree to it, they can't do it. Most of the credit card companies are trying to do that, but mandatory arbitration is void because it's asking you to give up something that you have the right to do. Any arbitration agreement asks you to give up your rights to proceed as to arbitration instead of following through with the rights that you have that you can do. I mean, the minute if any debt collector ever sued me in state court, I'd remove it to federal.
Okay.
One, to piss them off. Two, because it costs them $48,000 to do the removal. You remove it, they have to find attorneys that can go before the federal bench to do it. So it's going to cost them money. When I sued TransUnion, TransUnion said, the attorney told me after I took the settlement agreement of $1,000 that it cost their firm it cost TransUnion $184,000 to answer 4 pieces of paper. And the funny part is 99.999% of the time, the credit bureau will remove it to federal for you. And if they're nice enough to remove it to federal for you, you amend the suit and put every federal act you can think of and stick it in your lawsuit against them as a countersuit. Guess what? Now it can't go back down. They're stuck with it. I have a book, but it's not here. It's called O'Connor's Book of Civil Trials. Everybody should get the O'Connor's books. In fact, in your state, you're lucky because they have it for the county court, they have it for the district court, they have it for the appeals court, they have it for the Supreme Court. And that book is the cheat sheet. They send you this document, you open up the book to the page of that document, you look at it, oh, they're saying that, okay, let's see. Look up these 2 cases, read them. You read those 2 cases, read the 2 cases you got. You say why these 2 cases don't apply, you add your 2 cases in here, you file the paperwork back, you're done in 24 hours, and they're sitting there going like, well, now we got to answer that. Bang, you hit them with paperwork, now they're stuck, now they got to answer it.
Where can we find it? What's the name of that book?
It's called O'Connor's Book of Civil Trials. It's by Jones McClure Publishing. I'll have the phone number and that after lunch because I'll be bringing the book back down. I didn't bring it down. I forgot. But it's really cool. Those are neat books because if somebody does something against you and you look it up in the book and it gives you the case law that they have and the case law that you have. And you just look at what they're doing, okay, how does this apply to them? Half the time, attorneys put case law in a case that doesn't have anything to do with the case.
More than
And so you look up the cases that they did, and it's wrong. Okay? A prime example is the McKay Farms. McKay Farms is a dairy farm in Washington State. And he said I could say his name and all this stuff, so it's cool. The neat part about that is a bank's trying to foreclose on the farm. Well, bring it up here if you got it.
I think this is,
That's the old one.
that's the civil trial. It's
Yeah.
2003.
Yeah. It looks like this. It's a neat book. And they just came out just within 4 days. They shipped out the new 2004. And in here, where's the number? It's my favorite book, though. www.jonesmclure.com. And it's also